Today we are sharing a special episode of The Vicki McKenna Show. In today's show, where she and Right to Work's president Mark Mix comment on the latest employee freedom proposals in Senator Cassidy's package of bills and the PRO Act Light proposal by Senator Hawley. Now, let's dive right into The Vicki McKenna Show with Mark Mix.
Welcome back to the program. It's the Vicki McKenna Show. Standing by on the Middleton Ford hotline, Middleton Ford family-owned and your good neighbor Ford dealership for nearly 75 years, is Mark Mix, the president of the National Right to Work Foundation, to join me to talk about the dueling GOP proposals on labor. Mark, I want to what's going on? It's like Sean O'Brien comes out and says Teamsters are not going to endorse a Democrat, and that green lights some Republicans to say, oh, that means we're going to just start doing everything big labor orders us to do. That surely seems what seems to be motivating Senator Hawley, but it is odd to find a bunch of Republicans seemingly cheering on things like card check and the PRO Act and the elimination of private contracting and all sorts of other horrible things.
Yeah, to say that's interesting, Vicki, is an understatement. But yeah, that's what's happening. But the good news here, the silver lining, if you will, is that the attention to labor policy is growing. And people are beginning to look at what the National Labor Relations Board has done over the last 90 years using the platform of the National Labor Relations Act and giving union officials dramatic powers over workers. And it includes things like card check unionization and the elimination of the secret ballot and the lack of transparency when it comes to unions' expenditures for politics and ideological causes which workers disagree with. So the battle rages, and the more attention we get to it, the more I think the American public and, frankly, union members and working people across America will understand just how unbalanced the power is when it comes to union officials over the workers they claim to represent.
All right, well, let's talk about what Hawley is proposing. And then we'll talk about what Senator Cassidy is proposing. And again, good people like both of these guys. They like Cassidy, they like Hawley for different reasons. Hawley has, sort of inexplicably thrown in with big labor. And he's introducing and putting pressure on people. He's very powerful to do really, have Republicans sign off on horrible stuff. So what is Hawley's latest? And then let's talk about how Cassidy's, legislative package actually, it's not anti-union, and it would make a lot of sense.
Yeah, indeed. Well, first with Hawley, his bill, Senate Bill 844, that he introduced probably a month or so ago, maybe more. A lot has happened over the last month, Vicki. But this bill really is kind of part of the PRO Act. You and I have talked about the so-called PRO Act before, and this was big labor's number one priority during the Biden years, during the Obama years. They had all kinds of things that were packed into one bill, including the repeal of all the right to work laws across the country, the virtual elimination of the secret ballot election, allowing secondary boycotts of union targets for union certification, lots of mischief there, and lots of new power for unions. Josh Hawley, while he didn't come out and actually say he supported that bill, what he did was issued a issue paper at the beginning of this Congress with 5 or 6 points of things that were actually part of the PRO Act. And he's now introduced one bill, this Senate Bill 844, that literally says when a union is certified, you have to start negotiations in 10 days. You have to finish negotiation in 90 days. And if you don't finish it, then you get a 30-day period where federal mediators and bureaucrats come and potentially, Vicki, literally potentially, a federal government bureaucrat could impose a contract on a private business for up to 2 years. That's really dangerous stuff. And I don't know how a guy that supports, individual freedom and workers' rights, allegedly, would say that he would allow the federal government to impose a contract on a private business.
Good golly. So how does the National Labor Relations Act greenlight the federal government imposing contracts on people? I mean, where is he getting his legal arguments that this legislation would, even not be challenged and fail in court?
Well, I think it'd obviously be challenged. We would be interested in challenging it because one of the things that would happen in the 24 states that don't have right to work laws is the federal bureaucrats would be imposing what are called union security agreements, which is the first thing, which is a mandatory subject of bargaining, is the first thing union officials want in any new contract is union security, which is literally what it is, Vicki. It says everyone must pay dues to the union in order to stay or keep working here, get a job or keep working at this plant. The second thing you want is dues deduction. We know that virtually every contract in a non-right to work state has those two clauses in it. So we believe that Hawley doesn't know this, but he may be generating an opportunity for us to use a state action legal argument that gets to a constitutional question, which is exactly what we got to in the Janus decision. We wanted to see was the state was an actor.
Yeah, so this is an attempt to use the government to do an end run around right to work.
Yeah. Exactly.
Okay. So Wisconsin, that was a hard-fought battle here in Wisconsin. Nobody is proposing to take it away in Wisconsin, by the way. So you come in and you have the feds saying, oh, this is, sorry, there's a federal law that says we have to do this. Now, mind you, these union elections can be done via card check, essentially, now, thanks to the changes that Biden had imposed to the National Labor Relations Board. So what's Cassidy doing? This is almost like the polar opposite. And again, as I say, as I'm reading through it, and I haven't looked at all of the details of every piece of legislation, but it doesn't look on its face to be up yours to the union. It just looks pro-worker.
Yeah, it gives a little more transparency. It gives some kind of clarity to another Supreme Court case that we won called Beck versus Communication Workers of America that protected private sector employees from being forced to pay for politics or ideological causes or things that were completely unrelated to union bargaining as a condition of their employment. So there's some stuff, protection on the picket line. There's some stuff about new awareness about what the unions are doing with the money. And this is a package of 8 bills that includes bills from Senator Tim Scott from South Carolina, Senator Jim Banks from Indiana, Senator Tuberville from Alabama, and Senator Cassidy from Louisiana. Interestingly enough, those are all right-to-work states, and so it's good that we're having this conversation. But to your point, Vicki, the one solution that's not here, although the bill we've already got introduced, is the National Right to Work Act, which says, look, let people pay dues if they want to, but don't force anyone anywhere in America, and let the default in federal law be in favor of voluntary unionism as opposed to compulsion and force. We'd like that. This is a small step in that regard. But again, it's bringing interest and more attention to the powers that union officials have over workers. And when you look through this package of legislation, you say, my gosh, really? Unions can do this, unions can do that. And why do we have to solve a problem that says workers should know what the unions are spending their money on?
Like, why can union officials block workers from trying to throw the union out? That's one of let's have everybody, try to wrestle with that question themselves. That's one of the things that would be cured, as I understand from Senator Cassidy's legislative package. Like, why should the unions be able to say, no, you can't throw us out? No, we want to throw you out. We don't want you here to go away. No, sorry, you can't do that. Like, most Americans would say, well, that makes no sense.
Yeah, indeed it doesn't, Vicki. And we right now at the foundation, we have over 100 cases that deal with this. The union is blocking opportunities for the workers they claim to represent from getting out. And they're using what are basically precedents that have been established by the National Labor Relations Board over these many years. They're not statutory conditions that the NLRB has to or quote unquote must enforce. There's only one statutory bar that stops the decertification, which is called the contract bar. But there's a successor bar. Now, if a company buys a company that's going out of business and they have a union contract, that union contract must go with it. There's other bars that have been created through precedents that say, oh, yeah, well, if it's an unfair labor practice charge, we can throw the union out, or we can throw the union decertification election out, which they did. They've done in several cases over the last 4 years for sure.
So they just generate a bogus unfair labor practices charge, and they're good to go.
Exactly. That's what happens, really.
And this is because a bunch of bureaucrats who are not relying on statutory authority have just decided that's the way it's going to be.
Yeah, that's right.
Let's throw this out to the American people because most people think that's garbage. Most people say that's not fair. By the way, if you're, you buy a company, the union contract goes with the company. 2 years later, the workers say, we don't want that union anymore. Get out. No, I'm so sorry. It's like right to work laws. Even in Wisconsin, I mean, they make you have to basically contort yourself to get your protections under the law. And I remember in the very early days of it, they had to call guys like you. They had to call your lawyers and say, hey, they're not letting me out of the union. I want out of the union. So, So this dueling legislative packages, which I like, which means debate, which means exposure of what's really going on behind the scenes. Because if we don't do it, then, at the end of the day, campaign contributions will win. And you'll see Teamsters, UAW, they'll float some money to these guys just to keep themselves from having to actually make the case to their workers why they're better than not.
Exactly, Vicki. And it's been going on for a long, long time. And labor policy has always kind of taken a backseat to other issues that have quote marquee status when you look at the bright lights. But now, because of the economy, because of things that are happening in the American workplace, and because Donald Trump is talking about it, we are now getting a better debate and a clearer debate on the power of organized labor over workers. And obviously, their force and compulsion is the most dangerous power that they have. And I hesitate to say, oh yeah, let's just regulate it, let's fine tune it. Let's get rid of it and let unionism be voluntary, just like Samuel Gompers, the father of the American labor movement, said way back in the late 1800s and early 1900s. The workers of America adhere to voluntary institutions. That's so clear and so true, but yet here unions are relying on legislative power to maintain themselves over the workers they claim to represent.
Ooh, I would say that in many respects, they're not even relying on legislative power. They're relying on executive bureaucratic power that doesn't seem to have, kind of any basis in the Constitution or in law. So here's another thing that it really has to be on the table, and that is an overhaul entirely of the NLRA. Why is no one just out there bold enough to say, look, this thing has been turned into Swiss cheese over the years. We need to take a look at it, and we need to see whether it even has any it makes applicable sense to the way modern Americans organize themselves or employ themselves. And I mean, why not just take a look and say, this doesn't make sense? Let's look at some past Supreme Court precedents and say, yeah, that doesn't make sense, that it's okay to commit an act of violence if, in fact, you are, engaged in a legit labor dispute. Pull it apart and say, get rid of this, we'll keep this, and have that fight.
Yeah, well, Vicki, we've been talking about that for a long time, and unfortunately, big things like that are hard to get people interested in because of the politics of it. And frankly, you're exactly right. When you talk about the union violence situation on picket lines, the Enmans decision from 1973 that says union officials are exempt from prosecution for acts of violence that are used to, quote, achieve legitimate union objectives. Who's in favor of that except for boss? Yeah, exactly. Yeah.
Nobody.
So you're right.
Here's the thing about that particular case. So I'd start talking about that. If I'm Senator Cassidy, I'm bringing that up. Even if Senator Cassidy's legislative package isn't doing anything about that, although it should, bring it up because nobody knows that's real. I say that to people and they look at me like I'm making it up, Mark, but it's a real decision and it really has protected people who have done significant harm to other human beings. I'm including, I believe, at least one homicide. You're not technically, although that guy eventually got prosecuted because you can't technically kill people. But you know what I mean? So let's just start talking about it because it's old. No one mentions it any longer, and it's just stuck back there in the dank, dark room that really needs some deodorizing.
Yeah, indeed. And when you look at litigation regarding union violence, you'll see the unions using it as a defense in almost every case. They'll say, well, you can't prosecute us for this. So, yeah, there's a lot of work to be done. We're continuing to talk about it. You do too, Vicki, and we appreciate that. It's important to continue to have a dialogue about this and expand the dialogue about it because the idea of force and compulsion have anywhere under our Constitution this grand experiment in self-government. And when a government forces and compels, and obviously a union say, well, you got to pay your taxes. Well, you're not the government, Mr. Union Boss. You're a private organization, so you having power equal to government is a real problem.
Yeah, you're a private political organization, and you happen to be a bunch of communists. Good to have you on the show, Mark, as always. National Right. Let's just say someone does need some legal help. What's the best website? I know you've got the Legal Foundation, and you've got the National Right to Work Committee, which works on legislation. So how can people best access some assistance?
Yeah, Vicki, if they have questions about their workplace rights, whether they be, in the public sector or in the private sector, they can call the foundation. They can go to the foundation's website at nrtw.org, and they can talk to an attorney. They could provide free legal services to them if something is inside of our jurisdiction and what we work on all the time on behalf of literally thousands and thousands of workers every year. We can help them with that. nrtw.org.
nrtw.org, and you've helped lots of people in Wisconsin. So reach out if you are worried that your rights as a worker are being violated. I appreciate the time on the program, Mark. Thank you.
Thanks, Vicki.